Y'all want to talk about a way to set up the perfect family fight? I'm talking about the type of fight that would have been worthy of Don King promoting. I'm talking about the type of fight that could break up families forever, that could impact bloodlines for generations. Type of fight that I'm hoping that nobody in your family gets into, and so that's why I am doing this video. A lot of times people think that when it's time for them to either create their will or set up their estate plan, or even when it's time to go to court and ask to have administrators appointed over an estate, family members will think that it's a good idea to have two, three, four, five, many people serving as the administrators, co-administrators, co-trustees, co-executors of wills, whatever kind of co-role you can think about. I've seen people want to have at least two, maybe three people, maybe more, serve as joint, we would call it fiduciaries. We can call it joint agents, joint representatives for an estate or for a person's affairs. And I'm telling y'all, this is something that people think, well, it would be good because we can split the responsibilities between the co-administrators. We can make sure that nobody has more of a burden than they need to. We can share the load amongst people. Some people say, I want to put some checks and balances in place. I want to make sure that I don't have a rogue person in place that will take over and deprive other members of the family. Some people think it's about being fair. It's about sharing the honor of serving in this capacity between family members and not showing favoritism and making it seem like, oh, well, I think this person's more responsible than the other. So what I'll do instead is just have all of my children or all of these people to serve as co-administrators together or co-trustees, whatever the forum may be in. I'm gonna be real loose with my words in terms of referencing co-trustees, co-executors, and all that. But what I'm really talking about is situations where someone is being placed as a fiduciary, as a person responsible for someone's business, someone's affairs, someone's estate, and they are thinking about putting more than one person in that role. Is that a good idea? I think that's the ultimate question that I'm talking about today. Is it a good idea to appoint co-administrators, co-executors, whatever it is, co-agents over a power of attorney? Is it a good idea? And the answer to that, as with all lawyer answers, are it depends. However, based on my own experience as an attorney who's been doing this for going on 15 years, I do not think it is a good idea to appoint two or more people to serve as co-administrators, co-trustees, co-executors, co-agents. I don't think that's a good idea. Like I said, it sounds good. We can share the load amongst multiple people. I could not have to make a decision between who I want to serve in this capacity over somebody else. Let's see, where's some other reasons? Accountability, making sure that one person doesn't just take control and do things that other people wouldn't want them to do. They want to have some checks and balances in there. And then those are the reasons that I had on here. But some people may not think about some of the negative sides of that, in that when you have more than one co-administrator, co-executor, co-trustee, under most circumstances, those people have to act as one person. So if there are checks to be signed, if there are decisions to be made, if there are legal documents to be signed, those things are going to have to be signed by all of the people who are co-administrators, co-executors. So you can imagine, I had situations where one executor was in one state and another was in another state, several states away. And we had to ship things all over the country, from me to my one client in one state to my other client in another state and back to me. And that made everything take like 2 or 3 weeks longer. And it was during COVID, so it just was making things way too long. But by that point, it was too late. We already had 2 co-administrators and we were just working through the process. It also can not only slow things down, it can, result that families might fall apart, fall out, let me say. I've had situations where co-administrators are working together. Things are perfect. They are just like so in sync. They say anything I think, the other person thinks, and whatever he wants, then I want it to. and then something happens and they don't agree like that anymore. So that's another situation where, it sounded like a good idea to have co-administrators, but then once they had that falling out, maybe one person wanted to take the estate in one direction and somebody else wants to take it in another. One person wants to bank at this bank and the other wants to bank at this other bank. Somebody didn't like what this other person said. Or the thing that really gets me is when other family members who are not part of that co-agent relationship start talking and saying, well, the other person is doing this, the other person is doing that, and then they start getting in that person's ear. Next thing you know, they have a falling out, they're disagreeing. Or family members start taking sides. They say, well, I like working with this administrator more than I like working with the other administrator. And then you have these groups of people who are siding behind different administrators and having a difference of opinion, and then now there's a big fight. So I'm telling you, these are the types of things that will break families apart. These are the types of things that will have people not talking to each other. These are the types of things that will, something that y'all really need to think about. These are the types of things that will have a court order that a court-appointed administrator be appointed to go into the estate. And basically, the 2 people who were serving as administrators before, the 3 people, the 5 people, now someone that the court has appointed who works for the county, usually it's going to be a lawyer who works for the county, they're going to come in and administer the estate for the family. So now it's taken out of the family's control, and they are in a position where they're at the mercy of this administrator. I actually just helped a client family of mine to get out of that situation where they had several co-administrators at one point. Everything was going well until one of their co-administrators died. And then as you know, they were fighting with each other. They ended up taking each other to court, and the court appointed a county administrator. That person served for multiple years and basically just held the estate up. Nothing was done with the estate for many years, and the family lost control of it. We were able to get the family back in control, but again, this is many years that have gone by that could have been, we could have made some progress on it, but instead we're using resources to get the property out of the court-appointed administrator's control. So I would recommend that if you are doing your estate planning, you're choosing executors for your will, trustees for your trust, agents for your healthcare decisions or your power of attorney. If you're in that process and you can choose, I advise you to choose one person to serve in that role. And you can always appoint successors so that if that person needs someone, if something happens to them, they die or they're no longer able to serve, now someone else can come in their place. You can appoint successors. You also can set things up in your estate planning to where if that person needs help, so for example, they might have an issue where they're not able to complete some task for the estate, then they can bring somebody else in to assist them. Another thing that you can do is, so that's with if you're doing your estate planning, have a trust or a will, and you're trying to think about, I want to set my person up that I choose in the best way possible. How do I do that? You can put that a successor trustee or executor would be put in place. You also can allow it to where a majority of the beneficiaries can choose someone to serve as the executor or the trustee of the estate. There was something else I was going to say that has slipped my mind now, but it'll come back later if it needs to. So if you are in a situation where you have someone who died, they own property, they did not have a will or a trust in place, so you are seeking to have an administrator appointed over their estate, over their intestate estate, then I encourage you to only have one person apply for that role as the administrator. And what I was going to say with the other thing that I forgot that I now remember, in both of those situations, you can always have members of the family working to support the administrator or the trustee or the executor, but they don't have to be the decision makers. They don't have to be the ones required to sign the paper. And that can keep things from being held up. It can keep fights from occurring with the people who have the authority over the estate, and just allow for things to work a bit more smoothly when you have one person making decisions versus two or three or a committee of people. So those are things that can, address some of the concerns that you might have. I don't want them to be doing this by themselves. It's a big job. I want checks and balances. To address that issue, I want you to know that you have your beneficiaries of your estate or your trust. They are going to, the beneficiaries or the heirs, they have rights to hold the person over the estate accountable. They have rights that are written into the law. And then if there is a situation where you had a trust or a will, then they have rights under that instrument to address any concerns they may have with the estate representative. So your beneficiaries and your heirs will have options to hold the person accountable if they start going off the beaten path, but it's not something that you have to try to alleviate by appointing multiple administrators or trustees. So yeah, I just wanted to share those things with y'all based on my experience. I'm telling you about things that I have seen, that I've experienced, that I have struggled through working with my clients. And if I can prevent you from having to struggle through these situations or have fights in your family that has to be resolved by your great grandchildren later on, and I'm saying this because this is what we're dealing with many of my cases, then you would want to think about the possibility that if you appoint co-administrators, co-trustees, co-executors to serve, then there could be a falling out in the future. So it's strongly encouraged to appoint one person and to put checks and balances in other ways so that your family does not end up in a situation where folks are talking about how they lost their land because the co-administrators or the co-executors or the co-trustees couldn't get along. This has been another video from Attorney Veronica McClendon. Please like this video, subscribe to my channel, and if I can help you with anything, if you have a legal matter in Georgia that we can assist with, let us know if we can help you. And if you own heirs property, we can talk with you about your situation and maybe refer you to a practitioner in your state if you need help with heirs property issues. We are happy to help with that as well. Y'all have a great day. Take care.